Welcome back to another episode of the Divorce and Separation Coach podcast. This week, we're talking about cost orders. Now, that's a technical term, but it kind of does what it says on the tin, as in it's an order from the court to get your spouse to cover your legal fees. Now, this is something that people are often very interested in, especially when they feel that their ex has caused an escalation of the conflict and therefore the fees. So we're going to try today to demystify a little bit cost orders, understand exactly what they are, how you go about getting one, and what are your odds of getting one, and on what terms if you do have a case. So to discuss this, I've invited Rita Gupta. Rita is the managing director and the co-founder of LGFL Limited, which is a boutique family law firm that advises complex and high net worth clients nationally and internationally. Her particular specialism is in cases involving neurodiverse families. Rita is passionate about promoting diversity in the legal profession and helping future lawyers. It's great to have you, Rita. Thank you so much for joining me.
Thank you for the opportunity.
So maybe we start with the basics. Could you talk to us a little bit about what a cost order is in the context of family law and when it might potentially be awarded?
Absolutely. So a cost order basically is a court direction that the one party pays the other party's costs in respect of their legal fees or certain parts of their costs. So for example, it might not be their solicitor's cost, it could be the cost of a report or another sort of similar disbursement, as they say, that may be incurred. And I think there is a lot of misinformation about cost orders. And I
I
think
agree.
sometimes people think, like the whole no win, no fee thing that, if somebody's not successful, they will have to pay all of your costs. And that doesn't apply in family law. And unfortunately for people, and if you think of the interaction between family law and human emotions, it can seem a very bitter pill to follow when you may feel like the aggrieved party or that the other party is prolonging the proceedings, making everything more difficult, increasing your legal fees by sometimes quite oppressive communications and correspondence, that they wouldn't necessarily have to pay your fees. But
Yeah.
what I would say is that, last year, as of the 29th of April, there was a change in the rules about NCDR, which is non-court dispute resolution, which has put more obligation on parties to consider their reasonableness in the way they
Yeah.
conduct themselves. So I think to summarize it in a couple of sentences, I think you're looking at a cost order when somebody's conduct, their litigation conduct and behavior has been unreasonable and goes beyond being difficult. Because if you
Yes.
think about that in a matrimonial context, generally the parties don't see eye to eye on many issues. So what one person may think is subjectively difficult and obstructive may not actually be within the context of law, and they may be very much within their right to ask for that further disclosure or to ask that report because that's just them conducting their case. So I think it's really important to understand that this whole, the other person will pay my costs if I definitely am successful isn't going to work in family law. I think it's furthermore really important to distinguish between children proceedings and financial proceedings because they are different. And if you think about children at proceedings, the welfare of the child is really the paramount concern, and it's paramount concern in financial proceedings as well as the court's consideration. But it's nuanced, isn't it? What one parent may genuinely think is in their child's best interest may be very reasonable as may be a different view. So for cost orders in children at proceedings, they are more rare because what you can't have is a party feel they can't go to court to have additional time with their children, or that it creates further tensions between the parties because a cost order has been made by a court,
Yeah.
or similarly that it takes vital family resources away from the child by making a
Yeah.
cost order.
Yeah.
So sometimes a judge may think, well, you are being very difficult, but what would be the net effect of that? Well, that the mother who has the child for most of the time may have to then pay a cost order, and what would be the impact on the child? Um, but recently I have had a cost order
Yes.
in the children act proceedings, and I
Yeah.
just wanted to give this example. It was very protracted proceedings, incredibly complicated, with three children, very different needs, very dispersed ages, a SEN element, so a child with quite considerable needs, and then a school fees issue. And whilst one party suggested that my client was difficult and obstructive in his approach, he was actually following a court order. Um, so the judge didn't accept that element of it. But there was one part of an enforcement application that they were insistent on issuing and perhaps quite relentlessly pursued that technically was inaccurate. And on that basis, the judge looked at it in the overall context and said that element of those proceedings which he had wanted to issue,
Yeah.
I think was unreasonable. So I'm going to get you to order those costs, but it has to be assessed. And the difficulty on that was it was a joint application. So it was, we weren't going to get all your costs in respect of
Yeah.
that. And it was the element of it. And I think that's really important to note that you're not necessarily going to get all your costs either. And in fact, I haven't
Yes.
had any where you're going to get all your costs.
Yeah.
And we'll talk about in the mechanism in a little bit later on, but generally you'll get a proportion of your costs. I've not had any, as I stated, where you'll get all of your costs in respect of that. So that was in Children Act proceedings, and it was quite specific. They
Yeah.
asked for a lot more costs, and it was just ordered an element. And I almost felt that it was slightly a token
Mm,
to
okay.
acknowledge where we were at by the judge rather than maybe necessarily agreeing with the whole approach being incorrect. I've had more common cost orders made in financial remedy proceedings. So that's the
Yeah.
financial settlement, financial proceedings relating to a divorce. Now, in those proceedings, generally, costs will be paid by you individually. You will pay your own costs.
Yes.
So again, I think that's where it's again a really bitter pill to swallow, and can appear quite unfair because you can have parties who are very in very different financial positions. They could have ability to raise credit, they could have a really high income, they could have family who pay legal fees. So it can morally seem very wrong
Yeah.
that they're having to, fund legal proceedings for someone who's got more clout
Yeah.
financially on the legal fees. But I would say that in recent times, I am noting the court are more likely to make a cost order with unreasonableness in the litigation
Oh,
conduct. And
interesting.
again, we can delve into that in a little bit more detail to give
Yeah.
examples. But one was that the other party had filed two Form Es.
Okay.
And they'd filed two financial disclosure forms, which meant not only had we had to consider them, but council had had to reconsider them. And actually, throughout the duration of the case now, we're working on multiple documents that
Were they
have
saying
led to,
different things then, these two
yeah,
forms?
they weren't actually even the same document. So it's
Okay.
just added to the bulk of documents that we're going to have to consider. And in that, the judge was initially quite hesitant until my counsel suggested that he'd be inviting the judge to publish the judgment. And then lo and behold, he did actually make an order for partial amount of costs of the additional time that was then spent by the wife, myself and counsel in considering all these financial documents because you don't file two Form Es. You file one statement of truth within these
Yeah.
proceedings. And it did cause a lot of confusion.
I'm sure it did.
Yeah, and it's going to carry on causing confusion. And the other was actually as recent as Monday. And I think this is really important to know. It's very timely for this podcast that the other party who the judge made the order against was a litigant in person. And
Okay.
I think this is another unfairness of the system that you can have people who are litigants in person who are not incurring any legal fees, massively increase the represented party's legal fees by
Yeah.
bombarding them with correspondence, trying to get advice through the back door and saying, but surely this is this. I mean, I'm quite careful on how to do that, but I think some younger lawyers may get quite easily sucked into almost vicariously advising the other party, but their client paying for it.
Yeah.
Um, and the approach was really unreasonable. She was advised at the FDR that actually, if it was found that the husband didn't have any assets available for division, that there may be ramifications of that, but still quite single-mindedly drove these proceedings to a final hearing because she had nothing to lose, in
That's
her
exactly.
view.
Yeah.
She had no assets anyway, and she just thought, well, I'm not paying for a lawyer. I had put out an open offer, in fact, two open offers that were increased to say, look, on a commercial basis, there isn't anything, but we want to settle this case. Rather than spending that on legal fees, my client will give you this amount. She
Yeah.
again refused
Oh,
and refused to make an open offer. The
oh
net
yes. She was
effect
being
was that at
vindicative,
the
really.
final hearing, the
Yeah.
judge determined there were no assets available for division. My client had incurred thousands of pounds worth of legal fees, and in fact, the judge didn't find that unreasonable. And I think he was probably relieved that he was dealing with one represented party where the papers were created, they had counsel, there was assistance. It's difficult for judges dealing with two litigants in person. And rather symbolically, he made a cost order against her. Now, it was only for £250, and it was a drop in the ocean of what my client had incurred. But it was a shock to the system for the
Yeah.
litigants in person because
Yeah. It's a
she'd taken
message.
a day of court time, she had incurred thousands of pounds, and she seemed completely oblivious to her own requirement to comply with the rules. So I think if you are going to take an approach as a litigant in person that you'll wham up the other party's legal fees, waste valuable court time, and let's be honest, court time is precious. There are so many cases that can't get to court. For what is a spurious, misguided application, you could be faced with a cost order
Yeah.
against you. And actually, £250 for her is quite a lot of money.
Yeah.
And finally, the other one that I had was, and I think this one was unfair. The judge made a cost order because a challenge to an expert's instruction had not been dealt with properly. We had some very legitimate objections to the way in which it was conducted. But the judge just saw my client as the much financially much stronger party. He made it without a cost breakdown actually being provided, but only made it for the barrister's fees for that day. So didn't make
Okay.
it for any of the preparation or additional work. So I think it's really important to note that generally I'm seeing their partial costs. I haven't had many
Yeah.
where they're all of the costs. And actually,
Yeah.
what you have to do is fill in a form called an N260, where you will break down all the work, the
Yeah.
time, the level of the fee earner, what their hourly rate is, and usually you'll get a proportion of them. But they're three examples of where recently cost orders have been made in respect to that. And, once we can perhaps pause for a moment and maybe delve in a little bit deeper about the sort of conduct that could
Yeah.
put you at risk of a cost order.
Yeah, absolutely. And I think that's an often a very big misconception, this idea that you can go ahead and spend as much as you want because you're going to get it back at the other end. First of all, it's not guaranteed, far from that. But also, in a
Yeah.
lot of cases, it's not for the integrity of the amount spent, which in a lot of ways is a really good way of putting a guardrail towards the kind of behavior you were describing, where someone's going to go crazy, just
Yeah.
spending and spending and spending, knowing that they or hoping that they're going to get the money back at the other end.
Absolutely. And generally, in financial remedy proceedings, you're each responsible for your own costs. There's
Yeah,
certain interim applications that if you're unsuccessful at, you can have to pay the other party's costs. For example, interim maintenance pending suit, ones with third parties, any specific interim applications. If you're unsuccessful at, you could pay the other party's costs. But generally, it's deemed to be, that you pay your own costs. And I think the other thing I find is that clients can sometimes have the view that this separate little pot of money for legal fees, it's all generally one pot, unless you
yes,
have parents who are going to just give you the legal fees as a gift or something.
yeah,
It does ultimately come off the balance sheet. So I think litigation conduct and the way you guide your client is really, really important. I've got one at the moment,
absolutely.
and I'm trying to propose we use something called the accelerated procedure, where we skip the first largely administrative hearing, save a few £1,000s on both sides, and deal with it on paper. And it doesn't seem to have been considered by the other side. So I think they may get a rather directed correspondence for me to say we do have a responsibility to look at proportionality
I
of
agree.
costs in light of the entire assets. If we're not arguing about millions, we can't spend half of the assets that would rehouse the parties on legal fees.
I agree.
But I do think there is this misconception that, they'll just get paid from this separate pot, that they
Yeah.
won't, they'll impact everything.
Yeah, absolutely. So when the court is deciding, on an application for a cost order, do they have a specific list of factors that they look at to make that
There,
decision,
there
or is it
are
really the judge's discretion?
Absolutely. I mean, I think for children proceedings, I think it's the litigation conduct and unreasonableness and perhaps the pressure it's placing on the other party. It's more nuanced, I'd say.
Yeah,
The form that you will need to complete is the N260, and you should be serving that 2 working days in advance. And I would usually always serve it sooner. In the one that I indicated that was, in my view, unfair, they hadn't produced one.
ah,
But that's why I do think it was very unfair, because it was just almost thrown in, and it was almost like the judge wanted us out the room and made this order, but it wasn't at the point where we could challenge it. But really, you're looking at general litigation conduct. So with the new rules, you've got to have considered NCDI, have an obligation to do that, but it's not always relevant. For example, in an abuse case, you can't make somebody necessarily go and mediate. But
yeah,
remember, non-court dispute resolution doesn't just consider mediation now. It includes arbitration. It
yeah,
includes private FDRs like early neutral evaluation, etc. So I think the general approach would be, if you're not complying with court directions, so, for example, in that case with the two formees that hadn't properly complied with the court directions, if you've specifically had another one, our client was acting in person until he came to me just before the final hearing. There's a historical costs order because he was very late in the directions, which had a significant impact on everything else and the sets of proceedings. Somebody not actually attending mediation at the outset and
yeah,
appearing as though that's an unreasonable option. Remember, you have to have a MIAM signed off
yeah,
generally in proceedings, which is the mediation assessment form, unless you're specifically exempt. Not putting open offers out to settle. That was a criticism on Monday, that even though she was a litigant in person, she had actually, conducted, it was very clear on the court order that they had to put an open offer to settle. And while she said, well, that one wasn't, why did he make the open offer to settle before all his disclosure? The judge was like, well, because it's disproportionate for us to prepare for a final hearing. The offer was made on a commercial basis. It was very clear that we will seek costs from this date.
yeah,
Um, and also if somebody's taking a really relentless and single-minded approach to a particular issue that's not reasonable.
yeah,
So if they're, just literally laboring a point unreasonably in the
yeah.
bounds of the context of a case, and I think you are at risk of a cost order. Similarly, non-disclosure, if you found to have not disclosed something, and just generally the concept of unreasonableness in
Yeah,
litigation conduct, it has to be not just difficult. But I
yeah,
think more and more the courts are looking at this in general. And I think they would look at it in the context of the case. If, as I said, if you've got a case where there aren't many assets and looking to house children both sides, then taking a difficult litigation approach where you're not actually making any attempts to settle a case and trying to drive it towards a final hearing does put you at risk of costs.
and that's kind of what it boils down to, right? Is if somebody who's not trying to negotiate and who's just escalating conflict, and then as a result, all the fees are going up as well. That that's kind of the umbrella across all the examples you gave.
Yeah.
It sounds like that would be
But it's
the main
not as
bit.
common as a lot of clients would want,
Yes.
and not as common as perhaps, they should be made sometimes. As I said, I was very surprised in that one where we didn't even, properly give notice of cost.
Yeah.
And then there's some cases where you think the other side are being very difficult and the judges, sort of fudge the issue a little bit. But I think it is
Yeah.
happening more and more. And I think Monday was an example. You're a litigant in person, but you have wasted court time, thousands of pounds on the other side. I'm going to make you
There's
pay
going to be a
250
consequence.
pounds.
Yeah. And so have you seen that since these new rules that you alluded to? So in April last year, 2024, there were new family procedure rules that required new applicants or people who file with the court to have shown or to document if they've used out of court dispute resolution
Or
solutions,
they've considered it, they've
at least
reasonably
considered it.
considered engaging with it. I mean, I'm just about to put somebody on notice of that, but I haven't
Ah,
had any specific ones. Yeah, I mean, I think we are using it more and more in cases where we are saying, come on, we can, you are putting your client at risk of cost by not seeking to engage with this. But I haven't had any specifically where the judge has, adjourned the proceedings off or said, right, you need to go and do that, probably because I've always considered if it's appropriate.
yes.
Um,
So there hasn't, you
uh,
haven't noticed an increase in requests on the back of those new rules?
I think I've noticed an increase in people threatening them in
Ah.
correspondence. And I think that's not necessarily helpful because then I think that just spread the misinformation that, oh, we'll go for costs. And it's like, well, would you really get a cost order on that? Is it really unreasonable in the context of the issues that we're resolving? You
It's
being
used as
able
a
to
threat.
fight, yeah, absolutely. You being able to fight your client's case or your client genuinely looking into a piece of disclosure or pursuing an issue isn't necessarily a basis for cost just because you don't like what the other party is saying, right?
Absolutely.
But I do think it is definitely accepted, and we're as practitioners, we are more aware of our obligations
Yes.
to consider it. For example, I'm a huge fan of private FDR hearings. I think they are, in most cases, hugely proportionate because if you get rid of use the accelerated procedure for the first hearing, you go directly, you can just walk out with what, having done one hearing with a settlement. Most of them do settle. And it's really unfortunate when you're seeing practitioners on the other side who are not guiding their clients to even consider that
Yeah.
and are saying, oh, but it's cost, but they're actually spending the costs in the
That's what
reams of
happens.
correspondence that doesn't actually get us
Exactly.
anywhere. So,
I agree. So that's quite an interesting segue into what I was going to talk about next, which is kind of the practical element of applying for a cost order. Is there a specific stage in the process that you need to request it? So, and then how does that work in practice? And also, I guess one thing that I'm thinking of is there's a bit of a tit for tat approach where if you say you're potentially gonna ask for a cost order, the other side might retaliate and say the same.
yeah, I've
So
had
maybe
cases like that. We both have actually, a final hearing that we went for, we both put cost applications in, and the judge didn't make any
yeah,
in respect to that. Or so if there's an interim application, like you applying for an expert to be instructed or in interim maintenance, and you'd apply for costs of that specific hearing. You do the Form N260, full breakdown from your solicitor of what they've spent the money on. So it's not, oh, I want 10 grand. It does have to
yeah,
be very clearly specified. If you're legally represented, your lawyer would be able to create that for you. As I say, it breaks down the different hourly rates. A judge, for example, isn't going to give a director like me my hourly rate to prepare a court bundle. They'll expect that to be done by a more junior
okay,
lawyer. And you need to serve that on the other party and file it with the court. So they're interim applications. I've noted if it's general financial remedy proceedings, it would be perhaps more dealt with at the end.
okay,
So costs could be reserved until be dealt with at the end of the proceedings. And then I think in a way we've got a better idea of the size of the pot and what would be the implication of it, because sometimes a cost order could completely make the end result of what we'd be trying to achieve ineffectual if it meant that, well,
yeah,
that cost order then meant that that person couldn't house with their children.
yeah,
So it is nuanced in family law, isn't it? It's not like, and as I say, like, and you don't win, no win, no fee, or, if you lose in this case, you would definitely pay the other party's costs. It doesn't work like that in family law. But I think with interim applications as you go along, I think you should be raising the issues as and when you don't store it to the end and say, oh, by the way, I think you've been unreasonable throughout these
yeah,
proceedings. You'd be raising it. And certainly from open offer stages, there are times in proceedings naturally. I always say to my clients, I do a cost benefit analysis with you. So,
yes,
like, what are we now? Where have we got to? What are costs going to be further to get us further? How far apart are we? And I think
yeah,
that there are points naturally whereby you will put an open offer out to settle to another party and you'll put them at risk of costs. Because
Okay.
after that, and sometimes you do it on a commercial basis, you might actually, it might be like well, we're not going to be end up any differently, but let's save ourselves because you can't put a value on your emotional well-being.
Yeah,
Let's
that
save
can be paid
ourselves
for. Yeah.
months of this, but actually I'll offer this because then we won't incur the months of stress, maybe further mortgage payments, instructing counsel, just in order to conclude matters. But I'm doing that before I go and incur the costs of counsel or drafting very detailed statements or, further financial disclosure. So you often would make an open offer out, put people at risk of costs at on a commercial basis before certain preparation is done, such as the case on Monday. But unfortunately, the party wasn't willing to listen, and so my client did incur all of those costs for a final
Yeah.
hearing preparation. And that's another bitter pill to swallow because obviously, if you're a litigant in person and if there's a litigant in person on the other side and you're instructed, even if you're not the applicant, you're having to do a lot of work that they should be
Yes.
doing ordinarily.
Yeah.
So you're having to prepare the court bundle,
Yeah.
um, which is a lot of work, and you're generally communicating with someone who may raise issues or be obstructive that perhaps an experienced lawyer would know that that would be how the documents would be prepared, and it runs up your costs, and it can
Yeah.
seem really, really unfair to clients that essentially they're having to do wasn't their application, but they're having to pay their lawyer to prepare a lot of the documents that should be
Yeah.
done ordinarily by the other side.
And really, I guess the logic behind these cost orders is to prevent the kind of abuse. I mean, we see it a lot with what we call litigation abuse, right? Where people are constantly taking their ex to court over and over again over every little issue, with this intent of kind of bullying them into getting their way because they want to avoid the costs. That's really the logic behind organizing creating those orders, isn't it?
I think absolutely. Remember, the court's resources are finite. The family justice system is under so much pressure. We can't have people like Monday should never have happened.
Yeah.
Monday's final hearing, 1 day's worth of court time should not have been utilised in a case such as that. And so there have to be messages that are sent out by judges, and I think they're more willing to do that now. I really do think that. And I think you're right, in any abuse type scenarios, litigation abuse, where someone may, on the face of it, seemingly come across as having a legitimate issue to argue, but it's unreasonable in the general context of it. Obviously, in Children Act proceedings, if somebody makes repeated applications, you can apply for something called a Section 91, subsection 14 order, which means that they'd have to get permission of the court before they keep applying in the future. But I think these are designed to send messages to people that you can't just carry on making these applications to the court. There's lots of applications you can make to a court, but they may not be reasonable in the context of a
Yes,
case and they may
exactly.
not be successful. But
Yeah.
the impact on the other person is there is a nuisance value, isn't there? There's a
Yeah.
stress that's attached to them, and potentially emotional harm. Being served
Absolutely.
with having to go to court is scary, which is another reason why I think early neutral evaluation, private FDRs are so valuable for parties to be able to resolve their differences outside from the actual court setting and be given the time and expertise really to guide them.
Yeah, so I guess just one last question before we wrap up. Putting myself in the shoes of somebody who's receiving an offer from the other side saying, we might be seeking a cost order. Uh, is there anything that you can do to try and minimize that risk, of
Yeah.
the other side
I,
asking for a cost order
I
against you?
think I think if you are a litigant in person and you receive something like that, you need to seek some advice on it. Don't just be hell bent on pursuing it, thinking, well, hey, I'm a litigant in person anyway, because the judge could make an order that, or the cost order could be against the net proceeds of sale of the house of your share, couldn't it? So don't just think because you're saying that I'm not represented, I'm not going to have to pay them. I think any decent solicitor, if you have got a threat of a cost order, needs to be assessing and advising their client, is that just a threat? Because as I say, it is banded around a lot. Or is there genuinely a risk that a court could deem that conduct to be unreasonable? Don't ignore it, is one thing I
Yeah.
would say. And similarly, if there are court directions, generally courts do not like their directions not being complied with. Judges do
Which
not
makes
like
sense.
it when you decide to ignore orders. That's the point of them. And, particularly points when there's, times of open offers, or if there's finite assets, which in, a lot of cases there's not enough to go around. One pot of money is now housing two households rather than one. I think always do that cost benefit analysis and look at the impact on your ability to house, because these debts, you can say, I'm going to rack up legal fees on my credit card. Well, then when you go to get your mortgage, you might have to clear all of those, which may mean you can't buy that house. And also think primarily of your children. What is the impact on, essentially it's money away from the household and your future that you could spend on a very litigious approach. And the aim of this isn't, one of these TV shows where it's aggressively litigious. That's not the approach that the family court want to approach, even if people put an application. And sometimes it's really reasonable to put an application in because it gives a structure. It gives a timetable for people to work in, and it moves something on that's been, perhaps allowed to drift for a long time. But it doesn't mean that you can just carry on being, completely difficult and completely obtuse. So I'd say that, listen when people say that you may be at risk of a cost order, and if your lawyer says that, definitely listen.
But I think in general, I mean, whether there is a risk of a cost order or not, complying to court directions, doing things in a timely manner as required, that's going to make everyone's life easier. And if your objective
Definitely.
is to find a deal and to get on with your life.
Absolutely. And if you think about it, I think when delay generally is prejudicial, and I think that when proceedings last so long, the impact on parties' emotional well-being and then being worn down by the whole sets of proceedings, I don't think you're necessarily then going to always get the best deal, because I think it gets to a turning point where it's been going on so long, you probably compromise maybe a little bit more because you're just worn down, you want it done. I like to always try and resolve my matters before my clients, like, right, I just want it done.
I'm
Because
I
then I
can't
know
take this anymore.
they're making measured decisions, in respect of that. But, ultimately, I also think that, in financial remedy proceedings, there's an ES2, and which is the overall schedule of assets. And I think sometimes I say to clients, when they've got an approach, which I might not necessarily think is the right approach, put the figures in as they stand now, even if they're quite crude. Look at the net effect of the approach you're taking. And I think it's a good reality check. Because as I say, there's generally not some little magic pots at the end of the rainbow. There's real ramifications of taking an unreasonable approach, not only to the other party, but to you and your children, most importantly.
Absolutely. Absolutely. And that's where trying to keep the emotions out of the decision making and coming down to numbers and to facts can really help to make decisions that are actually the
Yeah.
right ones.
And being supported, I think, I always say I'm your lawyer, not your therapist. I listen with empathy and not sympathy, and that's where someone like you comes in, because I think clients who are getting support generally make much more measured decisions when it comes. They've got the headspace for the facts and
Yeah.
figures, and to consider, making decisions for their future and their children.
Well, thank you so much, Rita. This is so interesting and a lot of
You're
really
welcome.
interesting information for people to take away. A few good warnings as well. So that's been really helpful. Thank you very much.
Thank you.